Today, we are discussing about one of the most important and most litigated topics in government service law: seniority disputes, gradation list errors, and your legal remedies when your rightful place in the government hierarchy is taken away from you. Hello, friends. I am Advocate Sudip Patra, practicing in the Supreme Court of India and the Calcutta High Court. Seniority in government service is not merely a matter of rank on a list. It determines your promotion, your posting, your pay scale, and ultimately your entire career trajectory. When a gradation list is prepared incorrectly, the consequences for the wronged employee are severe and long lasting, which is why understanding the legal framework governing seniority and the remedies available to challenge it is absolutely essential for every government servant. The first principle you must understand is what determines seniority in government service. In central government service, the foundational document is the Central Civil Services Seniority Rules, read alongside the specific recruitment rules for each post. The general principle, as settled by the Supreme Court in a long line of judgments, is that seniority is determined by the date of appointment to the post, meaning the date of joining in the substantive post, not the date of confirmation, not the date of passing a probation exam, and not the date on which the appointment letter was issued. The Supreme Court has repeatedly held that if an employee is appointed earlier than another, his seniority must be counted from that earlier date. And any departmental instruction or office memorandum that contradicts this principle without statutory backing is liable to be struck down. A provisional seniority list is exactly that, provisional, and the mere fact that it has been issued by the department does not make it final or binding until representations have been considered and the list is finalized. The second major concept that every government employee must know is the Rota Quota rule, which governs inter seniority between direct recruits and promotees when both categories fill vacancies in the same cadre. Under the Rota Quota system, vacancies are filled by direct recruitment and promotion in a fixed ratio prescribed by the recruitment rules. For example, one vacancy by direct recruitment and one by promotion, alternating. The seniority between a direct recruit and a promotee is not determined by who physically joined the post first. It is determined by which slot they occupy in the rota cycle. This is a source of enormous confusion and litigation. The Supreme Court has addressed this in multiple landmark judgments, including in the context of All India Services, Central Secretariat Service, and Railway Services, consistently holding that the rota must be applied strictly as per the recruitment rules and that any deviation from the prescribed rotation in the preparation of the gradation list constitutes an actionable illegality. If you are a promotee who has been placed junior to a direct recruit, despite the rota cycle placing you in a senior slot, or if you are a direct recruit who has been unfairly pushed down by a promotee not entitled to that slot under the rotation, your remedy lies before the cat. The third area we must discuss today is the impact of interdepartmental transfers on seniority. This is particularly important for central government employees who move between ministries and departments, either on their own request or in the public interest. The law draws a critical distinction between the two. When an employee seeks transfer to another department voluntarily, he is generally treated as a fresh appointee for the purposes of seniority in the new cadre, and his previous seniority does not carry over. This is the rule, and it has been consistently upheld by the courts. However, when a transfer is made in the public interest, meaning the government itself directs the transfer for administrative reasons, the terms of seniority in the new cadre must be specifically stipulated in the transfer order. If the order is silent on seniority, or if the new department arbitrarily places the transferred employee at the bottom of the list without following the applicable rules or DOPT office memoranda, that order is challengeable. The Supreme Court has held that a government servant cannot be made to suffer seniority wise as a result of a public interest transfer unless the relevant rules specifically provide for it and the burden of justifying the placement lies on the department. Finally, let us discuss the procedural roadmap for challenging a wrong gradation list. The first step is always to file a written representation before the competent authority, typically the head of department or the cadre controlling authority, clearly identifying the specific error, citing the rule that has been violated, and attaching documentary evidence such as your appointment order, joining report, and the relevant DOPT circulars. This representation must be filed promptly because courts are reluctant to grant relief where there has been unexplained delay. If the representation is rejected or not decided within a reasonable period, the next step is to file an original application before the Central Administrative Tribunal, if you are a central government employee, or before the State Administrative Tribunal, or directly the High Court if you are a state government employee in a state without an SAT. The CAT has full power to set aside an incorrect seniority list and direct fresh preparation in accordance with law. If the CAT's order goes against you, a writ petition to the High Court under Article 226 on questions of law remains available, And from there, a special leave petition to the Supreme Court is the final remedy. Time is your enemy in these matters. The moment you see an incorrect gradation list, begin your documentation immediately and consult an advocate who specializes in service law.